anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give me your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Okay, good morning. I see the first case is all ready, but just bear with me for one moment while I introduce the panel to you. My name is Ariane Buno. To my right is Justice Peter Rubin, and to my left is Justice Paul Smith. We have 5 cases on for today, and we plan on taking a short break after case number 3. Just a couple other housekeeping matters. We've read everything that you've submitted to us. We know the case well, all your cases well, so you can get right to your main points as soon as you can when you have your argument. Also, just to remind everybody, there is no rebuttal in the appeals court. All right. So the first case is number 2022-0190, Commonwealth versus Joseph Schnupp III. Counselor.
Good morning, Justices. May it please this court, Scott Martin for Mr. Schnupp. First, I will let you know, I have a lozenge. I was battling some bronchitis. It's the only way to keep me from coughing. I mean no disrespect to the panel.
Okay.
I'll get right to the point. I trust that you have all read the submissions. In this situation, Mr. Schnupp, as you know, received one of the tens of thousands of letters that were sent out to defendants telling them they could revisit the issue of pleas that may have been unknowing, involuntary, and unintelligent based on a breath test. Mr. Schnupp elected to file that motion, and I would argue to the court, and I understand the position of the Commonwealth, is that he would have gone to trial. He would not have gone to trial because the evidence was so strong against him. I would submit that of those, I believe, 27,000 letters that went out, a presumption would be made that the people who did not file for retrials, those people may have realized, it's a reasonable assumption that those people may have realized that the case was strong and untriable aside from the breath test, and not people like Mr. Schnupp who elected to seek a motion for a retrial.
Can I direct your attention to a question I have with respect to the record?
Yes.
I understand your position that you think that the evidence wasn't sufficiently strong and that you could have impeached the credibility of police officers, and that's one of the motivations for your client to have gone to trial if he had known about the fact that the breathalyzer would be excluded. Yes. But he also argues that the quaff was, quote unquote, severely detrimental or severely impacted his employment status as a corrections officer.
Yes.
And I'm not really sure about that. Of course, in the affidavit, he doesn't talk about his employment. But you argue in your brief that, that there are those consequences. How was he employed in the 6 years in between the time that he actually entered the admission of sufficient facts and the time that he filed the motion for new trial?
It's a good question. He remained a correction officer for a while, although he let me know that he was concerned it would prohibit him with the admission to being impaired by alcohol for advancement and such. Subsequently, he lost his job. It was COVID-related for a refusal to vaccinate.
Okay, so that's not part of the record, but thank you for telling me that. That's okay. That's all right. In other words, the record does not indicate that he lost his job or that he was not granted any kind of promotion as a result of the quaff. Can we say that? The record doesn't reflect that.
The record does not reflect that, although that's one of those situations I would argue where you don't know sometimes. I mean, when you have applicants and they have nothing, and the person has a quaff for an OUI, a lot of times that would be pushed to the side. It's difficult. Nobody would.
But there's no allegation. There's no allegation here of that, right? There's no allegation that he was that.
I have no direct proof
Okay.
that he was informed specifically that he was prohibited from advancement, although he believes that it would cost him or would have cost him if he remained in that position. And it's certainly.
How do we know that? Because his affidavit doesn't say anything about that. And at the hearing, which was a different counsel that represented him at the hearing for the motion for new trial, just simply said he's a prison guard and this could affect his employment without specifying.
Justice Varno, I represented him at that hearing.
Oh, you did?
Yes.
Oh, okay, I apologize.
Attorney Noonan filed the appeal, but he was unavailable. I'm arguing.
Okay,
I represented
all
him
right,
at that.
well, okay.
Yes.
Yes, I see your name now, yeah.
Okay. So I did argue that, and I tried to perfect the record, at least that he had those concerns. As I said, it's difficult to obtain direct proof that would affect, although I think it would make sense that the inference a not guilty at trial would certainly be more beneficial to a person than an admission that they had engaged in that type of behavior, even if it resulted in a quaff. And furthermore, I argue that the consequences, certainly with an OUI as opposed to other charges, where you do suffer a subsequent offense, despite the admission with a dismissal, it should be looked upon differently than, say, other offenses where you would not be subjected to harsher penalties and subsequent offense implications with a dismissal already resulting.
Well, I think that we can say, without much controversy, that a not guilty is better than a quaff. I understand your point there, but the whole point of a quaff is that there is no conviction and it goes away at a certain point in time. So certainly that's more beneficial to an individual than, for example, a guilty finding.
It is, but it's also an admission that certainly can be used against you. You cannot deny that you admitted you could be found guilty. I mean, it speaks for itself. I understand the position a quaff is better than a guilty. However, here the argument is more based upon the reasonable probability. I mean, I don't believe the Commonwealth in their pleading and pursuant to the decision in Hallinan that there was government misconduct. I understand their position that maybe that was later on after the plea in 2017. However, I would note to the panel, it's not reasonable to infer that if Attorney Salinas, who was plea counsel, filed discovery motions and sought the type of information that was later on uncovered as the Anais litigation in Hallinan, that it would have been provided to him anyway. There was a team of expert OUI attorneys that were assembled, and they had experts from all around the country or potentially...
Can I interrupt you for a moment? I appreciate your efforts trying to obtain the transcripts, which were unavailable.
They were.
But I also note there is no affidavit from, is it Attorney Salinas?
Attorney Salinas, correct.
Salinas, and there's also in the defendant's affidavit, there's no averment that he relied upon his attorney's advice. It's more general than that. So what inferences are we to draw from that?
So it's a great question. I did not obtain an affidavit from Attorney Salinas. We're not arguing that he was ineffective. What I'm arguing is later on there was a team of expert OUI attorneys assembled, and they had experts for breath tests and what have you. And there was egregious government misconduct where they withheld purposely discovery. And there's no...
We're aware of the history of
correct.
OAT, but the question is, what advice did your client get before he changed his plea? It may be strong evidence if there were an affidavit from a counsel said that, you're twice over the limit, your only option is to admit. We don't have that here.
The defendant's affidavit states that he relied upon, that the breath test was reliable and that he would essentially was over twice the limit, and that's why he pled. And that his decision to pursue a trial would have been an easy one, but for that. And if I could briefly get into some of the points I believe that make it reasonable that he would have pursued a trial, because when I read the judge's decision, Judge Doyle's decision, on him opining that it was not reasonable, it ignores, I'm arguing it's an abuse of discretion because it ignores many of the favorable facts and that would highlight why a person would go to trial. And I would start number one. Cases, OUI cases where there's an odor, balance issues, speech, and eyes. If we pled all of those cases, you'd never go to trial. It's standard language that's contained in almost every OUI report. Judge Doyle indicates that the officer was giving the defendant a break and that he exhibited severe lapse in judgment by driving after he told him to park the vehicle in a parking lot, and he saw him 15 minutes later.
Right?
In a driveway, I'm sorry, in a driveway, and saw him drive 15 minutes later. But that ignores, that analysis is a favorable point for the Commonwealth, I gather as much. But that ignores the fact that if we're going to attribute that type of poor judgment to Mr. Schnupp, a fact finder may also attribute that type of poor judgment to an officer that would let another officer continue to drive after he observes him on a public way and is impaired.
That's true, but isn't the distinguishing factor in your case is that there's an admission by your client?
Let's talk about it. He admits at one point, he says, I believe I'm a .1. There's no clarity behind that statement. They don't specifically reference that it's a breath test, although Judge Doyle makes that assumption. Would that statement even come in at a trial where there's no reliability for even the defendant to opine him a 0.1? What if he meant him a 0.01? He believes that standard's a 0.8, I'm a 0.1. There's nothing behind that statement that would indicate it would even be admissible. Furthermore, it goes to a breath test, and there's no breath test in this case. That statement likely, I'm arguing, would not make its way to a trial. Furthermore...
Well, wait. It's not, it's not a refusal to take a breath test, which is what can't go to the jury. It's him just saying, in some way, I've ingested some alcohol, and then we can fight about what 0.1 means, right?
Right, exactly, but fighting about what it means is for a trier of fact.
So let me ask you this.
Justice Rubin.
What is the benefit of the plea deal he got, this quaff, 24D quaff? How is that better than a conviction? Because that's part of his calculus, the reasonable probability of going to trial. We don't know what the percentage chance of conviction is, but we do know there's some percentage chance. And I'm just trying to figure out, is this quaff deal really good, or is it minimal? What's the story with it?
I don't believe a quaff for a first offense OUI is extremely advantageous to a defendant. As I stated earlier, you're subjected to a second offense later.
I understand you're subject to a second offense later. I get that. Same as conviction.
And the
What
admission
about what are the other collateral consequences of a conviction that you don't have with a quaff? You know what I mean? I'm just trying to figure out how big a deal the deal is.
It's a great question, and one I've given great thought to. For example, if Mr. Schnupp were to go apply for an LTC, that admission can be used against him, where he'd have a stronger argument that they could not use that against him if he was found not guilty.
Can they use it against him if it's a quaff can be used against him? Okay? How about for deportation? I assume he's a citizen.
Non-issue for Mr. Schnupp, yes.
All right. So license to carry, possible job consequences, second offense. Any other differences between a quaff and not? I assume quaff for I don't know. Is this a felony?
It's a misdemeanor.
Okay, so there's no felon in possession, federal firearm restriction, I don't think.
Right, but under the discretion from a police chief, they can use that admission to prohibit you from obtaining a license to carry. A not guilty would, you'd have a stronger argument.
They could, but that's really rests on speculation, doesn't it? I mean, it's not necessarily does not necessarily preclude you from getting an LTC.
We don't even know that he has or wants a
does.
license to carry, right? We don't.
Sorry?
Does he have a license to carry? Do we know?
I believe he does not. I'm not aware that he has a license.
I'm just all right. So I'm trying to figure out why do people choose a quaff instead of a conviction? Now I get if it's a slam dunk, you choose it because whatever, it's less.
Well,
But
that's the argument
does not having a conviction on your record help you at all?
That's
You have to put it on a job application under, have you ever been convicted of a crime? Do you have, now, maybe it asks arrested or convicted and you get no big benefit, I don't know.
Well, I think the public is familiar with what a quaff is. And if a person is reading an application or they're reading a query and they say quaff, that person admitted that they did that and they got a break. The connotation that you got a break versus a not guilty, that you can explain, I was offered a deal, I said
And
no.
the quaff, after the case is dismissed, the quaff still appears on the query?
It does. It says CWOF DISM dismissed, yes, as opposed to NG, which you can explain. Like, for example, I had 2 trials this week. One was a guilty for OUI, one was not guilty. And my client is going for a job as a nanny. And I said, you can explain, you were offered a quaff every time we came to court, but you exercised your right to a trial and you were exonerated. And that has a much more favorable implications on her job than it is I got a break because I admitted I made a mistake.
Because following up on Justice Rubin's question, what about more practically? Doesn't a continuance without a finding versus a guilty finding carry a less of a term loss of license, less of a term probation? Are the penalties?
No.
They're
For a
the
first
same.
offense OUI, it's the same exact penalty you would get as if it was a quaff or a guilty. And it's why you see so many trials for OUIs. And furthermore, I'd argue...
Well, you could, but a judge could impose more, right?
Well, theoretically, they could give 2.5 years in the House of Correction,
Right, well,
but it's
that's not just
typical.
theoretical, the statute provides for that.
That's true. Yes, Justice, and I don't mean,
Right, so that's,
I'm not being flippant.
I understand your practice and what you know in terms of what happens in district
Right.
court, which is, we appreciate that knowledge, but in terms of actual, the statute, someone could go to trial and not get the same disposition.
But when a person is misled, as here, not to go to trial, as we cite in our brief, it's an individualized decision. And I appreciate that Judge Doyle might look at these facts and say, even as a lawyer, I would advise my client not to try the case. I believe it's a slam dunk. But let's not forget, in this case, when the officer sees him driving 15 minutes later, prior to the lights going on and him being stopped, there's no civil infractions. I saw him earlier. I told him not to drive. I believe he was impaired, but there's no civil infractions. That's great evidence for a jury. I'm running out of time, so I wanted to highlight, because the crux of our argument is that the case was triable. There's no field sobriety tests. There was a recent accident that may have impaired Mr. Schnupp momentarily when the officer first arrives on the scene, where he made an observation believing he's impaired by alcohol, but people could be impaired momentarily that they were shooken up by an accident. Now there's no breath test. There's a witness, and Judge Doyle relies upon this witness several times, I believe, in his decision, saying, we just came from a Marine ball. That witness is not named in the police report. That statement is not coming in at a trial, so it's not favorable to the Commonwealth. There's a slew of evidence here that is favorable for Mr. Schnupp to go to trial, and he wishes to elect that. I understand Judge Doyle thinks this might be a slam dunk for the prosecution, but it's not. And Mr.
Okay, so
Schnupp
I've
has
let you summarize a little bit, but you're over your time now. But you can be assured that nothing that you've argued in your brief is going to be ignored.
Oh, I know. I just wanted to give the analysis.
No, your time is up. It's
Yes,
time
yes,
to sit
ma'am.
down. Thank you.
Yes, Your Honor, of course.
Good morning. May it please the court, Kristen Jang for the Commonwealth. In this case, the defendant failed to demonstrate a reasonable probability that he would have sought to proceed to trial if he had known that the Commonwealth would not have been able to use the breathalyzer test results. That's a totality of the circumstances test as articulated by Scott. And here, there was compelling independent evidence of the defendant's impairment, as I've listed out in my brief. In addition, the defendant gained several advantages.
Before you, could I ask you, I infer from counsel's argument that the Commonwealth was arguing that he did not fall in the Hallinan category, but you're conceding he does, correct? That there's a presumptive government misconduct, correct?
Correct. So we're under the second prong of Scott Ferreira here.
Right.
Correct. So
Under the first prong, though, you're conceding Hallinan controls.
correct, exactly.
Very good.
We're
Just wanted to
conceding
clear
there
that up.
was.
Thank you.
Yes, we're conceding government misconduct here. So we're just under the totality of the circumstances test, whether it would have been reasonable for him to proceed to trial here. So he gained several advantages from deciding not to proceed to trial. So as was discussed during my brother's argument, you know, the maximum sentence is 2.5 years. That's the maximum he would have been facing. But whether or not that's likely, we don't even know. We don't have an affidavit from trial counsel as to what he would have said if he would have known that the Commonwealth would not have been able to use the breathalyzer test. That's the record is completely opposite. We have no idea what kind of advice would have been provided to the defendant. All we have is in his affidavit, I was told that, you know, the breathalyzer makes it such that you shouldn't try this case, and that's all we have here in the record.
But that's, other than the fact that the motion judge, who was also the plea judge here, said that the affidavit was not credible. So
Correct.
we do have that. But, you know, the explanation in the affidavit that I was told that, you know, that the breathalyzer would be introduced, it's pretty compelling reason to take a quaff, wouldn't you say?
I suppose, but it also doesn't say, there's no indication about the other evidence here outside of the breathalyzer. What the advice would have been absent the breathalyzer, we have no idea. If you contrast Hallinan, there's discussion of a affidavit from trial counsel saying, if I had known that wasn't coming in, I would have absolutely advised her to proceed to trial, given the evidence in that case.
I see. So you're saying it's possible that the defendant here was advised not only about the per se theory, but also on just an impairment theory, and that the impairment theory would also have been potentially in trial counsel's view or defense counsel's view problematic for him. And you're saying and you're saying the void there, the absence of that evidence is something that we should be considering. Is that right?
If there was evidence that his trial counsel at the time was of the opinion that if the breathalyzer test didn't come into evidence, that he would have advised this defendant to proceed to trial, that's absolutely relevant. I'm not saying it's dispositive, but we just don't know. We just don't know what the advice would have been or what the advice was at the time. And it's the defendant's burden to bring that before the court for consideration.
Okay.
And if they're
Counsel,
I'm
I have
happy
a
to answer
question.
questions.
You would agree that the OAT scandal was a momentous, kind of a big event, correct?
Absolutely.
And Hallin's finding is serious. It's, presumption of government misconduct.
Yes.
And seeking relief under Hallin and this defendant, under Scott Ferrara, do you believe the issue he's raised is substantial? He has a BAC that's twice the limit, correct?
Yes.
So would you agree he's raised a substantial issue to begin with?
I guess I'm not understanding. A substantial issue.
For a motion for a new trial, that he's raised a substantial issue, that he had a breathalyzer that was twice the limit, and again, there's alleged government misconduct.
Yes. Yeah, absolutely.
And I ask you that because I agree so too, but this judge didn't. He didn't hold an evidentiary hearing, because when a judge determines there's a significant issue, they're required to hold an evidentiary hearing.
That's true.
And what follows from that is this judge relied on reports and his own assessment of the reports and affidavits, correct?
That's true.
And we give no deference to that,
We give no deference to the reports or the judge's
to the
findings?
judge's assessment of the reports and the affidavit.
You do, it's an abuse of discretion standard, but in terms of the deference to the factual findings, that's correct, because he was just looking at papers, which you're
A
in.
document.
Yes, this panel is in the same position as the judge. That's correct in this circumstance.
Very good.
Yeah, that's correct. But I'll just leave it there. Thank you.
Can I ask a question? Maybe I'm looking at this from a slightly different way. We have egregious government misconduct.
Yes.
Because that's why we're here. And the test isn't, would he have gone to trial? It's, is there a reasonable probability he would have gone to trial? The double the legal limit breathalyzer means at that point there was probably no reasonable probability that he's going to trial. But once you knock that out, you have things that you can contend about.
Yes.
And he does get a quaff,
Yes.
and I assume that's better than a conviction, although it hasn't quite been explained to me how, although, I mean, I just think myself, but maybe this is just about reputation or something. I would rather not have a conviction on something, but I'm not sure. Quaff is not great either for a lot of things. We see cases all day long on appeal from trials where there's evidence not unlike this, including I drank 3 beers at a social club right before you, including sort of admissions and things. And those people go to trial.
Yes, that's true.
So isn't there a reasonable probability, I'm not saying he would have, a reasonable probability that someone without that test would have gone to trial? And if reasonable probability is the standard, partly because we're erring on the side of protecting the defendant against whom egregious misconduct, played a role in their decision, why isn't there a reasonable probability if people bring these things to trial all the time?
They do. I think there are a lot of facts in this case, though. There is not just a simple admission. There's not just...
No, but there's not arresting him in the first place, at the place. If he's such a drunk driver and these are cops, why aren't they arresting him? You know what I mean? I'm not saying a jury would acquit him. I have no idea. Yes, there's a lot of evidence.
Yes.
But there's stuff to argue about,
The Commonwealth definitely acknowledges that, but at the same time, he did get the benefit of a quaff. The case was over then. He can move on with his life. There was one very brief mention of employment consequences just at the hearing, not in any of the pleadings before the judge as to explain what those were. So I don't even know what that means in terms of what the employment consequences would be. It's fleshed out a little bit in the brief, but that wasn't before the trial judge. So,
Do you have a different view of the benefit of the quaff?
well, just that it was over. I think the peace of mind of having the case over is worth something. Two, he only got a 45-day loss of license. He didn't have to serve any probation. He's not facing a potential jail sentence. I know that's not common, but it's a potential. So yes, I think there was significant value to taking that deal instead of proceeding to trial. If there are no further questions, I'm happy to rest on my brief.
Not for me.
No further
Thank you
questions.
very much.
Thank you both. Thank you. And we hope you feel better. All right, the next case before us is Commonwealth versus Jeffrey S. Foley, number 2023-0335.
Morning. May it please the court, my name is William Corman. I represent the defendant in this particular case. At the outset, I recognize the heavy burden that the defendant has in this case. There's no doubt about that whatsoever. The thing that I find complicated in this case is this. The Commonwealth files a motion regarding the first complaint witness, and they say the first complaint is this particular person, Mr. Ernst. Defense counsel, based upon the information that she has at the time that the case is going forward, says, yeah, based upon what I've read, that's the first complaint witness, and we have no objection to him being a first complaint witness, and they move forward to trial. Then at trial, things shift, and the Commonwealth, in their brief and at trial to some extent, has basically said, hey, it's not up to us to figure out who the first complaint witness is. We thought it was Ernst as well. And that's where the problem in this case lies. And respectfully, it's this subtle undercurrent of both the prosecution, and I say this respectfully, sort of shrugging their shoulders and saying, what do you want from us? Which is then sort of echoed by the judge, and that's actually the phrase I used in my brief. The judge also was like, hey, look, we're at trial, what do you want to do?
Are you saying that the prosecutor had a duty to determine more from the victim in the case before going to trial in terms of conversations or anyone else that she might have told?
So what I would suggest is this. If the Commonwealth is filing a motion to admit first complaint evidence, the Commonwealth has an obligation to find out who the first complainant is.
Let's say we agree with you, okay? Reasonable point. But in this case, there's no evidence that the Commonwealth did not believe that that was the first complaint witness. In other words, there's nothing in the record that implies that they knew beforehand that there was more than one person that the victim spoke with. In fact, that all was brought out on cross-examination by defense counsel.
I at the risk of being glib, because I think this case calls for it, it's shame on them.
So you think there was a duty, is my point?
Absolutely. Because I don't understand how the Commonwealth could process this case, prepare for trial, and not say to the alleged victim, 18 months after filing their motion regarding first complaint, just so we're clear, walk us through the day. There's something traumatic allegedly happened to you, you were sexually assaulted, what happened next? And I can't, as a trial attorney, understand how the Commonwealth is as taken by surprise as the defense is mid-trial when the victim of sexual assault, a case that's been lingering because of COVID and other reasons, it's been lingering for so long, they never say to the victim, what happens next?
How do you know that?
Well, because that's what the prosecution seems to imply, both in their
that we
brief
never
and
asked.
I'm sorry. I apologize, Your Honor.
They don't imply that they never asked her what happened. They're going to put her on the stand somebody has asked her what happened.
I hope so. I hope so, but we have a situation here where, again, if the Commonwealth had never filed the motion regarding the introduction of the first complaint witness, different story entirely. We're trying this case, it's district court. I think the phraseology used in many a case from this court is, the hurly-burly of the district court, 15 cases on for trial a particular day. But that's not what happened here. They filed a motion, and I would suggest that the creation of that motion, filed by the government, puts an affirmative obligation on them to find out who it is.
Don't you have to do some discovery to find out if they did? People say things at trial that they've never said before. We see it, and I see it a lot, and we only see appeals, obviously, from convictions, but I see it a lot in sexual assault cases where someone suddenly says, like, well, I told my cousin, or, I mean, I've seen even about who the first complainant is, surprises happening at trial. It happens all the time. But the premise of your discovery violation argument is that there was a way to have it not be a surprise.
Sure.
And it seems to me that you need to do some post-verdict discovery, see every interview that they had with, assuming you can, see every interview that they had with the victim, see what everyone wrote down, see what dates it was done on, and so on, right? Because I just don't see how you've shown that they should have known this without knowing that they weren't diligent.
What and I appreciate that, Your Honor, I certainly do. What I'm suggesting is that the burden, once the government files that motion, because again, in their brief, they talk about, I believe they mentioned that there are other avenues available to them, so on and so forth, at trial court. But again, we have a situation here where it's the Commonwealth putting forth, this is who the first complaint witness is. And I will say this, it also morphs a little bit, because then when that person, Mr. Ernst, doesn't show up, they're like, now we're not calling a first complaint witness. In a trial, they say, look, no harm, no foul. We aren't calling a first complaint witness anyway. So what ends up happening is the defendant, I would suggest, is almost double blindsided, because number one, they're prepared for Ernst to be the first complaint witness, and then like, well, now there isn't one because we can't seem to find the guy who's moved out of state. And then secondly, now there is a new first complaint witness, which no one knows about because the Commonwealth didn't apparently prepare for trial. I don't really know.
Let me ask you a question. Experienced trial counsel would have issued a subpoena or sought a subpoena for that first complaint witness's testimony, correct?
And she did.
Well, he didn't appear with a subpoena.
I think that they couldn't. He moved out of state, and I think he was. They weren't able to find him, or they weren't able to serve him with a subpoena. I believe that, and I think it's I think it's actually in the Commonwealth, one of the footnotes, there's a conversation about, we tried to get this guy, he's moved out of state,
Right.
So on and so forth. And then I think trial counsel says, if I knew the mother was the first complaint witness, I would have subpoenaed her. But this is the first time I'm hearing about it.
Well, let me ask you, the first time they hear about it, they go sidebar.
Correct.
And I was surprised that this Commonwealth was really silent at sidebar, are they not? There's no strong statement or surprise that, wow, we didn't know that, Judge. That's news to us.
I'm correct. They don't say, oh my gosh, we're all surprised by this. I'm not trying to read anything into that. But again, I think that the judge's response to this is, again, almost this, what do you want me to do here?
Well, the judge responded to a motion for mistrial, he denied it, but there wasn't a motion to continue or a motion to pause the trial, correct?
That is correct. That is correct. Absolutely. That's correct.
And that would have been incumbent upon defense counsel to do that at that point, to request a continuance.
I would suggest that there was an opportunity for many people to suggest. I think the judge also could have said, I'm denying your motion for mistrial, but I'll give you until tomorrow morning to have your investigator go talk to the complainant's mother.
You'd have to demonstrate a substantial risk of a miscarriage of justice from the failure sua sponte to issue such an. You don't have an affidavit from the mother of what she would have said, or from, we don't know. Maybe, first complaint witnesses usually aren't favorable to the defendant. I'm not saying they couldn't be. They could tell you something that totally undermines the whole story because it's a different place, different guy, different car, something, but generally not. But without knowing what it is she would have said, how can we find a substantial risk of miscarriage of justice from not sua sponte, putting a pause on to let you go investigate?
I don't know that it's sua sponte, because I think trial counsel did say.
He asked, or she asked
Yes.
for a mistrial,
Yes.
not for continuance.
Correct.
And if you could have given a continuance, that's a good reason not to do a mistrial, right?
Correct. And I do think, and I think I mentioned it in my brief itself, that, again, trial counsel is left, again, blindsided mid-trial and has to make some decisions on the fly, which I think we all know can be very challenging in the light of everything else that's going on. I know that trial counsel, I try tons of cases myself, there's a lot going on at a trial, and no matter how much you prepare, one of the things that's difficult to prepare for is a witness saying for the first time, in light of the Commonwealth's motion, there's a new first complaint witness. And so consequently, I think that you have to give trial counsel some benefit of the doubt here in the fact that this is thrown at her in the middle of a trial in a case that's been going on for ages. I mean, 18 months after the Commonwealth files this motion, this case goes to trial. So for 18 months, if I'm trial counsel, I'm saying, Mr. Ernst is the first complaint witness. I'm preparing to cross-examine him based upon what's going on here. So again, I think that the two key points that I keep trying to hammer home are, it's the Commonwealth's motion that sort of gets this ball rolling, and then there's this gap, again, because of COVID, et cetera, et cetera. So I don't know what trial counsel could have done other than say to the Commonwealth, I've read all the police reports and I don't believe you, investigate more. That simply makes no sense. If there are no further questions, then I'd...
Well, no, I still have a question. You've made a pitch to us about how difficult it is to have things happen at trial, but in this case, counsel really made good use of the fact that there was a different first complaint witness identified by the victim in this case, right?
Yes, she did the best with what she had.
Well, she actually impeached the victim's credibility and pointed out that in the police report, the victim had said the first person she told was Ernst, and the police officer testified, that's what I understood, and so that was significant evidence. Would you agree?
I would say that trial counsel did the best with the hand she was dealt, but the proof is in the pudding, because at the end of the day, Mr. Foley's found guilty. So she may have tried to do what she could, but at the end of the day, Mr. Foley still got sentenced to the House of Corrections based upon indecent assault and battering.
But that's not really our standard of review, is it?
I understand that.
Our standard of review is whether or not how prejudicial or how did it cause a substantial miscarriage of justice, one of those two standards.
Of course, but I would suggest that if at the end of the day the defendant is found guilty, then it's kind of hard to say that there's no harm, no foul.
I guess our cases do say that.
I started this by saying I
appreciate your point of view, but unless we find that the error was, or the discovery violation or whatever is at issue is prejudicial, then we don't find that the conviction needs to be reversed, right?
The very first thing I said is I recognize the burden that I have in this particular case.
All right.
Things haven't changed in the intervening 12 minutes. Thank you very much.
All right. I'm going to check with the panel. No further questions. Thank you very much.
Good morning. May it please the court. Elizabeth Sweeney on behalf of the Commonwealth. The trial judge did not abuse his discretion when denying the defendant's request for a mistrial in this case, as the Commonwealth's witness on cross-examination made an inconsistent statement as compared to her initial disclosure to law enforcement as to whom the first person she told about the sexual assault was. This is not a discovery violation, and I would direct this court's attention to the sidebar, Volume 1, pages 135 to 136, from defense counsel's statement, where she says, I think that information is important and should have been disclosed, and if the Commonwealth was not aware of it, that's one thing. And I suggest that the record reflects that the Commonwealth was not aware aware of it. The police officer who spoke with the victim for her disclosure testified, and on Volume 1, pages 175 through 176, said that the first person that the victim told was Mr. Gordon Ernst, and he said that if the victim had said that she had told her mother, he would have put that in the report, and he testified that there was no information that the victim ever told him that she told her mother. This court is very familiar with sexual assault cases where victims do say different and inconsistent statements. I suggest that that's what happened here. The cases I cite in my brief, Commonwealth v. King, the standard for first complaint, and Commonwealth v. Morris say that inconsistencies are expected, and the Commonwealth did file their motion for first complaint, saying the first complaint was Gordon Ernst based on the information in our custody and control.
What is the obligation of the Commonwealth when that motion is filed? And it's been pointed out here, the motion was filed early on in the trial, and of course the trial got postponed for reasons beyond anyone else's control. Wasn't there a duty upon the prosecutor to double check that, to interview the victim and reaffirm the fact that that person that they have designated as the first complaint witness truly is, or they can rely on the police report and their initial interview and let it go?
I think that it's sufficient for the Commonwealth to rely upon the statements that the victim first made to law enforcement the day after, saying that the statement was Gordon Ernst, that the first complaint was Gordon Ernst, and that's what we relied upon. We filed that motion. I believe this case was charged in 2019, filed in 2020, and in 2022, on volume pages 1 through 6, we note that Gordon Ernst was no longer available. We were relying on the information that was provided to the Commonwealth as corroborated by the officer's testimony that the victim never mentioned her mother. And Commonwealth v. Beale, 429 Mass. 530, the Commonwealth is not required to inquire further at a defense request of information on behalf of the defense for investigation purposes. We're not required to make additional inquiries, and we had the police report stated and the officer testified that the first complaint was Gordon Ernst. If there are no further questions, I rest on my brief.
I see none. Thank you both very much. Okay, the next case is Commonwealth versus Stephen Martinez Santana, 2022-1245.
To the presiding justice, and may it please the court, I represent Mr. Santana. And I'll start with the two Commonwealth versus Guardado cases. If you'd like a 16L letter, I'm more than happy to provide one, but I imagine you're familiar with the
Your assumption is correct.
I figured so. This is a crack bunch of justices. Okay. With your permission, I'll then go ahead and move to the argument that I've raised in the brief. And that is with respect to an immunized witness. As trial counsel raised below, and as the statute, I think, clearly and plainly says, a conviction can't rest solely on the immunized witness's testimony, and so that obviously raises the question, what is the only, when we're talking about only evidence? And in this case, the immunized witness points the government's direction to my client, but there's nothing else in this transcript that shows that there's any independent corroboration. And I say independent because I think it needs to be. I'll just say this. Do you mean
independent corroboration of the identity of the perpetrator or independent corroboration that a crime occurred?
I think it has to be, as the SJC has said, independent corroboration of an element of the crime. And in this case, the government is able to point to the height of the defendant and proximity. Neither of those are elements in this case. And so all they have is the immunized witness saying that my client was the person.
I'm still hearing you zeroing in, as you did in your brief, on the fact that of corroboration on the identity of the of the perpetrator. But I don't read the cases as saying that. When they say you need to corroborate an element of the offense, that's only one element. I mean, that's an element, an important element, of course, identification, but there is corroboration that the crime occurred.
Yes, there is.
Video, so.
I'm sorry, I didn't.
There is more, I mean, there's more than just the testimony. There's also photographic evidence, et cetera.
Yes. However, the statute is in place because when somebody's immunized, there is question as to credibility because they're receiving a benefit for their testimony. And so that's why you need some independent corroboration of an element. And in this case, I think about the fact that they went and looked for the gun at the rest stop where the immunized witness said it would be, and there wasn't one. However, I'm concerned that even if they had found a gun, then everybody would have said, well, there's your independent corroboration, but it's still coming from that immunized witness. In this case, the police could have focused in on the clothing, as I discussed in my brief, to show that these men owned that clothing, or that they had been seen in that clothing. I mean, there has to be something independent of this witness, because a criminal investigation, as we have all read in our trial transcripts or have gone through at the trial level, gives to the jury or the fact finder kind of a step-by-step process of how the criminal justice system focused in on the defendant. But in this case, that is missing. There really is no investigation other than the fact that the police were able to get an immunized witness to name my client as the one who perpetrated the crime. It has to be more than that. Otherwise, the statute doesn't mean anything.
The cell phone tower data, that's investigative, don't you think?
It is, but it doesn't go to an element of the crime. Again, proximity is not, it's not an element.
Well, I understand it's not an element. You were criticizing the investigation. I was just saying there were some investigative steps.
There was some.
Is there any element of the 4 convictions for which he was convicted of, 4 convictions, 4 charges, is there a single element in which there is not corroborating evidence?
I don't see either, because I don't see corroboration for any of the elements, because all they have is, as I said, they can point.
You don't see corroboration that there was an attempt to rob someone?
No, there was an attempt to rob someone. The question is, who did it?
But the robbery is one of the elements, several of the elements of the offense. Right? I mean, did someone take a gun out? This guy, the immunized witness, says there was a robbery at this gas station. He also says your client did it. Mm-hmm. Your client goes on trial, the elements of the offense, and I'll include identity as an element of the offense, but the other elements of the offense are use of a weapon, attempt to obtain something of value from, whatever the elements of armed robbery are. And there's certainly corroboration of lots of them in a video of a person pointing a gun at a guy behind a cash register at a store. And I think the questions both of my colleagues are getting at is the case law, although it makes sense what you're saying maybe, don't we want to know that this guy was the one there, that the element, that the case law says, so long as the immunized witness is corroborated about any of the elements of the offense, the rest of his testimony is good enough to convict. And of course, part of his testimony is that it was your client. Of course, he could be lying, but that's right. That's for the jury.
Thank you for saying that he could be lying, and that's the whole point. It also
witnesses could be lying in every case.
Yeah, that's the whole point. And I'll draw your attention.
Convictions based on that.
Well, I'll draw your attention back to the decades-long litigation that we all did with Annie Dukin or Sonia Farag. The criminal justice system is a process. That's why we call it due process. And when you have a statute like this that says you need something more than just what this witness is saying, that's what I'm saying the statute is plain on its face. Because sometimes a fact finder can believe somebody who lies or perjures themselves. That's the whole point. That's why we have a standard of proof that is beyond a reasonable doubt. It's supposed to be set high.
But the SJC has said, notwithstanding the arguable reasonableness of what you're saying, that the purpose of the statute was to prevent just this kind of framing, and that if you don't have corroboration of the identity, it could happen. Notwithstanding that construction of the statute, the SJC says the Commonwealth has to introduce some evidence in support of the testimony of an immunized witness on at least one element of proof essential to convict the defendant, and we can't overrule the SJC.
I'm certainly not asking you to overrule the SJC, but I am asking you to look at Fernandez and Scallion and Dvorsky in the way that I'm framing it, because the way I'm framing it sets a high standard for the government to meet. The idea that it's even in Blackstone's commentaries. Better 10 guilty men go free than one innocent man go to prison. That's the reason we have a high standard. I'm not saying that you have to ignore the SJC's cases, but there's no set of facts in either of the cases that I mentioned like this. And this is a vehicle where you could actually say the government does need more. It looks like just the immunized witness's testimony was used to convict this defendant. Yes, there was a crime. We all know that there was. That's not in dispute. The disputed point here is who did it, and the only evidence of who did it is the immunized witness. That's my point. If that's the way the criminal justice system is going to go forward, then the statute doesn't make any sense. It's just a mere, it's paper. It has no meaning. You get my argument, okay. Are there any further questions?
No? No. Thank you very much.
Thanks for listening to me. Appreciate it.
Good morning, Your Honors. May it please the Court, Caleb Schonzer for the Commonwealth. The panel's questions of my brother already covered many of the points that I would have addressed. The one that I would add in response to my brother's invocation of the Blackstone commentaries is that the corroboration requirement that we're dealing with here is, of course, a creature of statute. It's not a common law rule. It doesn't have constitutional underpinning. It's a function of the statute, 20I. And so what we're dealing with is straightforward statutory interpretation and statutory language that doesn't specify either the form or the quantum of corroboration that's required. So instead, a rule of general applicability across all different cases involving immunized testimony. And it's clear, as the statute's been interpreted, that that corroboration doesn't have to go to identification of the defendant, but rather it's sufficient that it can be the commission of the crimes or an element of the offense, which here there is. Unless the panel has any questions.
Essentially, your point is that time to go back to the legislature and get the statute changed to be more specific and require something more, or persuade the SJC to interpret the statute a little more broadly.
There would be one recourse, Your Honor. Yes, I agree. If there are no other questions.
Can I ask this? I don't know that it, in the end, has any bearing. So far as I can tell, in every single case where the court has said these things, there is nonetheless some corroborative evidence of identity. This case seems like, and I'm not saying that the language of the SJC doesn't cover it, but this case is, there is no, in my view, corroborative evidence that it was the defendant who was the third person in that car and who committed the crime. No corroborative evidence that it was him. Now, maybe you say if the video shows someone of his size, maybe that's corroborative. The cell phone tower thing, we have some case, I remember, there's 40,000 people somewhere on the South Shore who are pinging off that tower. That's not quite placing him at the scene.
Right.
Does that matter? And am I wrong also?
You are wrong, Your Honor, and I'll get there. The
That
Commonwealth,
happens a lot, yeah.
I can empathize. The Commonwealth's position, of course, is that there was some other corroboration, which is exactly what you mentioned, the cell phone data, also the disparity in the height and the build of the two assailants. Set that aside, take your premise as granted that the immunized witness's testimony is the only evidence here identifying the defendant as the shooter. It still would not be unique, Your Honor. There's 3 cases that I cited in my brief where the immunized witness or witnesses, immunized evidence, was the only evidence that linked the defendant to the crime. The first is Jacobs. That's at 6 Massap Court, 618, 1978 case. And on page 621 of the decision, the court notes, no testimony other than that of the immunized witnesses confirmed that it was the defendant who stood at the doorway of the Normandy Lounge firing a gun at Johnson and Trioli.
But was his very presence there contested? I mean, I understand if you're fighting about
It was.
who was the trigger man, how you might, it might be different. But here, there's not even corroborative evidence that he was with them or in the car or at the scene, right?
Correct as to that.
Aside, the video and the...
Exactly, Your Honor, and that's correct. But no, the identity was contested in Jacobs as well. Now, you are right. The defendant in that case was at the bar, but it was disputed that he was the individual in the doorway. He said, no, I was, assaulted and remained in the other portion of the bar. I wasn't anywhere near the entrance. I wasn't the individual who fired the gun. But be that as it may, the court still found that in that case, there was only immunized evidence that linked the defendant to the crime. And the court went on to talk about the Scanlon case as well. This is a Supreme Judicial Court case, 373 Mass. 11, 1977, as another example in which there's only immunized evidence linking the defendant to the crime. I point the court as well to Commonwealth versus Turner. That's at 371 Mass. 803 from 1977. Court notes on page 812, there was considerable evidence corroborating this testimony of the immunized witnesses on various elements of the crimes, although none of this corroborating evidence directly connected the defendant to the crime. And then you have Commonwealth versus Doyle as well as a third example at 5 Massap Court 544 from 1977. There you had the fire chief testifying as to the details of the different fires around the area, but there was no evidence to link the defendant to those crimes except for the testimony of the immunized witness, Canavan. So, as much as my brother may present this as being a unique case, it's not, either in terms of the nature of the evidence linking the defendant or the fact that it was significant evidence, Your Honor. And point the court to the SJC's statement in Dabrowski, which is, indeed, it would be unlikely that immunity would be needed or granted if the prosecution had sufficient evidence to convict without the aid of a witness who would testify only if granted immunity. Or to say it differently, if the prosecution can make its case without the help of an immunized witness, it's unlikely to ask for or seek a grant of immunity.
Let me ask you, counsel, other states, commonwealths, have made the bar a little bit higher and have required a corroboration of a defendant's involvement, correct?
I think that's right, Your Honor. I haven't looked at those statutes myself, but I know that some of the opinions that we've been talking about here have referenced those.
Are you aware of any federal analog to the statute?
I'm not.
And if there were a federal requirement that there be defendant corroboration, would that trouble you that Massachusetts has a lower requirement protecting a defendant's rights?
I express no view on the matter, Your Honor. I think that the Massachusetts statute would control here as a matter of procedure, not substantive law, and it wouldn't be my...
Constitutionally, we can give more rights to a defendant than the federal Constitution, correct?
As a constitutional matter, correct, not as a statutory matter.
And you're saying that this doesn't draw from constitutional authority, this statutory authority, but it's not a constitutional requirement.
Correct. This statute, 20I, is the wellspring of the requirement in this case, and it's purely a creature of statute. It doesn't have a constitutional basis. The constitutional right is the right to due process and to be convicted of proof beyond a reasonable doubt. But in looking at that, you take into account the evidence presented by the immunized witness as well. And taking into account that evidence here, it's, I think, clear that there was proof beyond a reasonable doubt for each of the convictions, with the exception of his conviction on count 5, which was unlicensed or unlawful possession of a firearm under 10A, which brings up the Guardado issue, which is what I was going to end with, if it's all right with the panel, which is just to acknowledge that that conviction cannot stand in light of the Supreme Judicial Court's decisions in Guardado, including the decision on reconsideration. There was no evidence presented at trial as to non-licensure. The jury was not instructed on absence of licensure as an element of that offense. I would direct the court to the 5th volume of the trial transcript. The jury charge on the elements of the different offenses starts on page 14, and that is because this trial occurred in May of 2022 when the state of the law treated licensure still as an affirmative defense. And so no discredit to the trial prosecutor, to the trial judge. They handled the trial appropriately in light of the state of the law at that time. But given the change in the law since then, the Commonwealth's position is the defendant's conviction on count 5 cannot stand, should be vacated, but remanded for a new trial. Unless the panel has any questions on that.
And new sentencing on the other charges as a result?
Resentencing on just count 4, Your Honor. Correct. And again, I invite the panel, please, to take a look and check. But based on my review, I do think that the sentence that was imposed on that, it was just another concurrent sentence, Your Honor, exceeded the lawful maximum of 5 years. But there's nothing in the record to indicate that this was, a comprehensive or integrated sentencing package. I think that just that count could be remanded for resentencing. It's count 4.
All right. Well, thank you very much. Thank you both very much.
Your Honor.
All right, so we've heard 3 cases. We're going to take just a brief recess and come back and hear the last 2 cases on our list.
Come on, rise, please.
Sorry, 1 second.
Court is now in session. Please be seated.
Okay, still morning. Good morning. Thank you for your patience. The next case is number 2021-1021, Taney Place versus, do I have the right case? Taney Place, okay. You gave me a look like maybe I was reading the wrong one. I'm sorry. I'm sorry to interrupt myself. Taney Place versus Jamila Flanders.
That's the case, Your Honor.
Okay, great.
Thank you. Good morning, Your Honors. I'm Dick Bauer from the Lawyers Clearinghouse on Affordable Housing and Homelessness, and with me is Kathy McGrath, and we represent Jamila Flanders.
Okay, thank you.
She is haunted by the very publicly available record showing that she was defaulted in a non-payment summary process case, and that case should never have been brought because she gave notice to the landlord and moved out months before the case was brought. And she needs to have her name impounded on the docket so that she can move on with her life. The Uniform Rules for Impoundment Procedure set out 5 standards to be applied to impoundment. They ask who are the parties and what's the nature of the case. As you know, this is a case where Ms. Flanders moved out so that she would stop increasing her rent arrears and avoid the landlord having to evict her, but the landlord did it anyway. The second factor is privacy interest, and her privacy interest is in not having people know that this case was brought against her improperly. Not knowing about the case, but knowing that it was her, having her name on it. The SJC...
Does it
I'm sorry,
require an individualized showing of a privacy interest?
Yes, Your Honor. I think it is individualized. I think the general kind of harm was articulated by the SJC in the Hatcher case. And if I may read to the court, the SJC said, the harm to reputation can be especially serious where the unjustified litigation is a summary process action, where the mere record of an eviction proceeding can serve as a long-term barrier to a tenant when he or she seeks future
That's not
housing.
an impoundment case.
I'm sorry, Your Honor?
That's not an impoundment case.
That was not an impoundment case. That was just the SJC's articulation of the harm that happens to people. But you're correct, Your Honor, it was not impoundment. The third factor is the public interest, and we would suggest here that the public interest in knowing that Ms. Flanders was the person against whom this case was improperly brought, that there is no public interest in that. There's a public interest in what goes on in the courts generally, but there's no public interest, and especially no interest in landlords in knowing that she was the person against whom this case was improperly brought. The fourth factor is whether there's any constitutional right, and I would suggest that there's none implicated here. And the fifth factor is the reason, which is that this case is following her around. She has been rejected for housing because landlords know to go to mass courts, look and see if there's a case. And
That's not why she was rejected. She was rejected because there was a valid judgment, a facially valid judgment against her on the docket. That's no longer the case. It seems to me that you're speculating that something like that will happen to someone whose judgment has been vacated, and I don't see any evidence in the record of that, just speculation.
You're correct, Your Honor. We don't know and we can't know what's going to happen, but we can draw reasonable inferences, as the SJC did in the Hatcher case, that landlords are going to look at mass courts.
That wasn't even part of the holding. That's a, discursive discussion of something.
That's correct, Your Honor. And
So your point is that the mere fact that there was a case, despite the fact that it's been dismissed, hypothetically dismissed, vacated, voided, whatever, that is sufficient.
That's correct, Your Honor. And I note that even though the default judgment was vacated, if you look at the docket, which you'll find in the record, I think on page 7, you will see that the docket still shows default judgment.
Yes, if you don't read till 5 lines later where it says default judgment vacated.
It does say that, Your Honor, but then at the end of the docket, on page 7, where it shows the disposition of the case still says, and I will read it, the disposition still says judgment in summary process by default, and the judgment is judgment default in summary process. So despite the fact that if one reads the docket carefully, one can see that that was vacated, it still shows that as the disposition because the housing court leaves the original disposition on the docket.
So what can we do about that? Do you think that we have the authority to say to the housing court in general that they should change that practice?
I don't know the answer to that question about what your authority is. I would hope that if this court said change it, that they would do that. But they are regulated, obviously, by the trial court system and ultimately by the SJC. But even if that got fixed here, the fact remains that a landlord is looking, may not look through carefully and say, well, I see that it was vacated. I see that there's an affidavit in which he says that she had moved out. It stands out as a black mark against her because
Well, so
landlords-
what exactly do you want us to do?
What we're asking the court to do is to direct the trial court to impound her name on the docket. So instead of showing Jamila Flanders, it would show JF. And that way, a landlord who goes into mass courts to look and see, is there a case against her, will not find this case.
Well, it seems to me that that's not particularly narrowly tailored to what you're objecting to, which is that it looks like there was a judgment here. Right? Those are two different issues. If we disagree with you on impoundment, what should we order the court to do about the docket?
Certainly, I would ask the court to do two things. One of them is to enter a judgment in summary process, which the court refused to do. And secondly, to remove the disposition that shows that there's a judgment by default and instead to...
Did you ask for that, or you just asked for entry of judgment of
We did not
dismissal?
ask for that, Your Honor. We have asked the clerks generally, and this is not a matter of record here, we've asked the courts.
And let me ask you this. I also noted on the docket sheet, before the new litigation began in 2022, I'm just looking for it here. I don't know which, this housing court docket. I thought it said, as its final disposition, or the final line of it before the 2022 litigation was transferred to civil docket.
That shows as the last entry on the docket.
Yeah, but I do see this case
But you can see the
disposition and
disposition
judgments thing at the
remains
bottom.
there. But as we have suggested, I think fixing that would be better, but it would not be good enough because a landlord is still going to be able to find the docket, see that there was a case against her, and then the landlord has to say, oh, I see she was defaulted, but then I see she got the default vacated, I see that she ultimately got judgment in her favor. That is, frankly, Your Honor, not a good look for a tenant who's going to talk to landlords about renting apartments.
Lots of things in our dockets aren't good looks for the defendant, of course.
That is true, Your Honor.
And we get a lot of cases that wind up dismissed because of their absurdity in some cases, but certainly failure to state a claim in many.
Yes.
Right? But there's still, we have a presumption of public records in this
That's correct, Your
system.
Honor. There's a presumption, and so, we are not here saying every tenant ought to have their names impounded on the docket, but we're saying the rules call for a case by case, and this is a case in which it's not merely the landlord didn't state a claim, the landlord brought a case against her saying you're still there, knowing that she had moved out months before, and a case where the harm of the docket is unusually great. In applying the balancing test that the SJC has directed to be used, I would suggest that the balance strongly favors impounding her name here.
So
that
we
it
would
will
have
not
to-
follow her
sorry.
around.
No, go ahead.
So we would have to, what you're asking us to do is to say the judge abused, I think it was abused his discretion in not impounding the case.
That's exactly right, Your Honor.
So the discretion abuse, we are now entering an order that the name be impounded.
That's correct, Your Honor.
And then with respect to your other claims that you've brought to us, are you essentially saying that this one is the most important one and the others are secondary, or are you still, would you still be pursuing the other claims, which is, for example, trying to change the docket or entering some sort of order that says that the judge erred by transferring the case over to the civil docket in the first place? Because I'll tell you right now, before you answer the question, I don't see how we act on any of that, because it seems to be all moot. Everything has been voluntarily dismissed with respect to that. So two-part question for you.
Yes. So I think, Your Honor, from Ms. Flanders' point of view, impoundment is the more important. If the names were impounded, the fact that there is no judgment would be secondary to her. But we ask that that be done as well. It is, frankly, I suggest a no-brainer that a judgment should enter, and I agree with the court that it is moot at this point, but when cases become moot, the appropriate thing then is to enter a judgment to that effect and not just leave the case hanging there as if...
Well, you say hanging there, and this is what I'm a little confused about. I would agree with you if this case is hanging there and should have a notation that says judgment of dismissal entered, or voluntary dismissal, or dismissal, you know, at the time that the judge in fact transferred it to the other place, other docket, then I could see that if it's still hanging here. Now, I'm having a hard time because, as I said, if you picked up this docket and read it, and I know people aren't lawyers and I know they don't care, and the truth is the existence of the case at all, or any summary process case against any victorious or losing defendant may bother people to the point that they don't do something for them, like an arrest that's not a conviction, like whatever. At the end of the docket, the judge wrote, you argue incorrectly. I know nothing about this. I did see that at some point counsel for the landlord described it to the judge below as naturally it was transferred to the civil docket. I don't know, it still had to be reserved and so on. It says transferred to the civil docket. And then if you turn to the civil docket, of course, at the end it's dismissed. And I guess I'm just not sure. I mean, I could see entering judgment of dismissal at the end of the, I'm not sure it remains open in any sense. When a docket says transferred to another number, doesn't that mean this isn't the end? This over here is the end.
Well, it does, Your Honor, but with two caveats. One of them is there's a possession claim which is technically still pending in the summary process case, even though everybody agrees that there's no claim for possession there.
How's that? That's what. Where is the possession claim still pending?
The summary process case has never had a judgment of dismissal entered. There was a judgment for the landlord. That judgment was vacated, and that's the state of the docket with regard to the possession claim. Nothing has ever happened.
So you think that if it were proper to transfer it, the proper entry in the docket would read something like summary process action for possession dismissed, rent claims transferred to X docket.
That's correct, Your Honor, assuming that the transfer was appropriate. We've argued that it's not appropriate because the rent claims here are derivative claims. They're derived from the summary process case, and when the statute...
Could they have brought a separate civil case for the rent?
They could, Your Honor.
At that time. They didn't have to wait for anything else. That
That's
was
correct.
ripe and ready to go. So the judge has basically, you say inappropriately, helped them out
That's
by
correct.
instead of saying, look, file the complaint in the civil docket, we'll do it, transfers it to the civil docket while saying, of course, you still have to serve it.
That's right.
And you say that's wrong, but there's, well, maybe you do need a new one. I'm thinking about like relating back and.
And why is that wrong?
It's wrong, Your Honor, because rent claims are derivative of the possession claims. So this court in the Cummings case was confronted with a landlord who brought a summary process case that included a claim against the guarantor, saying we don't want possession from you, but you do owe rent, and we can appropriately bring rent in this summary process case, and therefore we can name you. And this court said, no, you can't if you don't have a
I
possession
understand
claim.
that, but this is not what happened here. What
That's
happened
right.
here instead was they got transferred over. Maybe that saves the landlord a filing fee. I have no idea what the benefit would be to just transfer it over. Maybe it's just ease for the housing court.
I think that's probably right, Your Honor, but as in the Cummings case, that's not good enough. The landlord in Cummings said, look, what's the big deal here? We can bring a claim against the guarantor. Isn't it just easier for everybody to bring it all in the summary process case? And this court said, that's not the question. The legislature told us what claims could be in here, and if you don't have a claim for possession.
So here's the thing. Even if we were to say the judge erred at the time that he transferred this case to the civil docket.
That's right.
None of that exists anymore. So now we're entering an order about in an area of which is moot, there's no controversy, it's kind of gone. But
That's
let's
right.
just assume that we'll exercise our discretion and do that, right? We'll figure that one out. If we were to do that, there's no guarantee that that helps your client. That's going to be an order that is directed towards the housing court. We don't have any control over how the housing court enters that kind of an order on its docket. And I don't see where, even if we were to do that, we could then order the clerk of the housing court, we want you to say this on your docket.
Well, I think the answer, Your Honor, is that you would direct the court to enter a judgment, and the court would enter a judgment as it does in every other case. It would be a piece of paper, judgment for Ms. Flanders, and then the clerk would enter that on the docket, and the piece of paper would then be there showing judgment for Ms. Flanders. So our request that she get judgment is not an extraordinary request. It's a everyday kind of request.
And the judge sort of implied that that was correct, that the summary process case was dismissed.
That's correct, Your Honor. He and Landlord's Counsel seemed to talk as if it was. At one point, Landlord's Counsel said, the case is dismissed, but we can all look at the docket, and we can see that it's not dismissed, that there's no judgment of dismissal, and that's what's supposed to happen at the end of a case, and specifically in summary process, if the landlord does not recover possession, that's what's supposed to happen. And let me just be clear in case I haven't been. We are not saying that the judgment in the summary process dismissing the rent claims is with prejudice. We are not saying that the landlord, by including summary rent claims here, somehow lost the ability to bring them separately. As Justice Rubin asked, the landlord could have just brought another case for rent at any time. The typical practice is landlords don't do that, but the landlord could have. And so the judgment of dismissal would not be with prejudice as to the rent claims.
Did counsel for the landlord ask to have it transferred, or the judge just volunteered, here, I'll transfer it?
Judge just did it voluntarily. There was not a request by the landlord.
That's how it appeared from the hearing.
Yeah.
Did you have a question?
I do. So if that's a practice, I think we can infer from the record this isn't a one-off, that these transfers occur.
They do, Your Honor.
And if that's a practice which you believe is not appropriate and is capable of evading review, it's perhaps something we should address.
Yes, I think so, Your Honor. It certainly does affect other people, and there are times when it's appropriate to transfer claims, but other times when it's not appropriate to transfer them. And in a case where the landlord cannot recover possession, that should be the end of the claims. And as in Cummings, or as in the Fafard case, which Cummings relied on, the party is free to bring those claims, but it has to be in a separate case. And it particularly matters in summary process for the reason that you can see here, which is that it then has followed Ms. Flanders when it never should have been brought in the first place.
Okay, well, I think we understand the issues. Thank you for your argument. We'll take the
Thank you,
case
Your
under
Honor.
advisement.
And so we ask that judgment enter in summary process and that you determine that the trial judge abused his discretion in refusing to impound Ms. Flanders' name on the docket. Thank you, Your Honors.
Thank you.
Thank you.
All right, now we'll get to our last case on our list today, which, and the next case is impounded, so I remind all the parties to be very careful and to not use anyone's names. The Department of Children and Families and another versus mother and father, 2023-0303. Okay, so this is a case in which the parties on both sides are splitting their time. So I'm just going to ask the first person who argues to just confirm how much time you are taking and how much time is left over for your for your sister.
Yes, good morning, Your Honor. I will be taking 7.5 minutes, and my sister counsel will be taking
Would you speak up, please?
We are both taking 7.5 minutes, so we're splitting the time equally between the two of us as appellants. Good morning.
Okay, thank you.
If you could move the mic a little closer to you, it might,
Like this?
Yeah.
Perfect.
we'll see.
We'll tell you again if we can't hear you, don't worry.
Good morning, Your Honors. Good morning, the Honorable Panel. My name is Yulia Fischer-Neer, and I represent the appellant father in this termination of parental rights matter. The law is clear. Substance abuse alone is not enough to end all legal ties between a parent and a child. In the absence of evidence that a parent is unable to provide the child with minimally acceptable care, evidence of the parent's substance abuse does not in itself make a parent unfit. Here, the record showed there wasn't a nexus between what the father did or didn't do and any harm to the child.
All right, so I have a question for you. I mean, I'm sorry to interrupt so early, but time is short because
Yes,
of
Your
all the
Honor.
divisions of time. Adoption of Catherine,
Yes.
I find confusing, and maybe you can help clarify what you think it means. It seems clear to me that it is saying in that case, mere ongoing, in that case, unrepentant addiction to drugs. It says cocaine, but there's reason to think that it means any drug. It would include opioids, as in this case, is not a sufficient basis without some abuse or neglect beyond that, whatever that is, to terminate parental rights. It also uses language about unfitness near the bottom of the decision. But at the beginning it says, we are unwilling to say that it's not sufficient to prohibit the parents from having unsupervised care of the child. Do you believe that addiction alone, serious ongoing addiction, let's say for the sake of my hypothetical, both parents are serious heroin addicts, do you believe that that could form a basis for removal of the child?
I think, Your Honor, that is not a simple question. I think it has to be case-specific. There has to be evidence that the child was harmed in some way.
Okay, so now you're
besides
saying,
knowledge.
you're not saying it's unclear, you're saying in the absence of additional evidence, let me also say, or expert evidence of what is inevitable, because that's what Catherine says, or evidence of abuse or neglect, you cannot remove the children from the household.
Correct. And in this case, Your Honor, despite the questions about the father's sobriety, despite father's less than perfect relationship with DCF and his lack of attendance at multiple court events, throughout the pendency of this case, bottom line is that the father's behavior did not cause harm to the child. This child was not abused or neglected. The child was loved, clothed, fed, and medically cared for by the parents. She had her own room in the apartment they were all living in. She was visible in the community. And this is the premise of our argument, Your Honors, is that the trial court used generalized language that father's substance abuse issues had endangered the child and that he failed to provide proper care for the child. However, in these types of cases, in cases where parental rights are terminated, the judge had the responsibility to make specific and detailed findings demonstrating that close attention had been given to the evidence and to face the troublesome facts as well. Here, the trial court failed to provide any substantive details of how the father specifically endangered the child, how the
Well,
child...
that's not quite right, but it goes back to my question.
Yes.
The way he endangered the child, the judge finds, and there may be more than this, is by allowing the risky behavior of exposing the child to the mother. Now, your premise is, yeah, but there's nothing wrong with the mother, so that's nothing. But that's what it says. It says he not only showed on this one-night trial visit, but that given the importance of that relationship, he can't be trusted to not expose the child to the mother, which is why I asked the first question about,
Yes, Your Honor.
is the mother neglectful or isn't she?
Correct.
And I'm having a very hard time with that. partly because Catherine does say we are not prepared to say that such addicts, let's say the cases are virtually on all fours, that such addicts may have unsupervised custody of the child. I don't know what supervised custody means. I don't think DCF sends people to live at someone's house, right? They remove children and put them in a different environment. And I'm just trying to figure out.
Yes.
And let me, now maybe what you're saying is there's an inference that we are no longer or not allowed to draw under Catherine. And that inference is that living with two drug addicts is a dangerous and unsafe place that puts the child at grievous risk of harm. You can imagine lots of circumstances where there's been no abuse or neglect of the child yet, but there is grievous risk of harm in a household, depending what's going on. People coming and going, people with knives and guns, you know, where you'd say, like, we're not going to leave a baby there. You know, we're going to take that kid out. And I don't think anyone would say, oh, no, you have to wait for her to, you know, actually be cut by a knife or, right? So I'm just trying to figure out, you still say, though, can't remove without abuse, neglect, or you didn't say it, but I will, expert testimony.
Correct, Your Honor. That is exactly what I'm trying to say. I appreciate you hearing my message. That is exactly my argument, is that this, in absence of additional factors showing appearance and fitness, substance use alone does not equal parental unfitness or specific harm to the child. It does not mean the child is harmed just because there is a parent or both parents using substances. That alone in itself. And in this case, this child was observed by DCF at the time of the removal. She was happily running around the home. She was mark-free.
Well, Counsel, what about the cigarette burns? And under the parents' care, in August of 2019, the judge made a specific finding 36 in her decision, factual finding, the child had 2 cigarette burns.
Well, the child did not have any cigarette burns at the time DCF came to the home. That was an allegation that was made by a third party.
And that was credited by the judge.
I'm sorry?
That was credited by the judge.
I understand that. However, DCF went to the home and observed the child. Police went to the home and observed the child. And none of these people, pediatrician had been observing the child. And there is no evidence that this child was physically harmed or abused.
But that doesn't really answer the question, which is that the judge made a finding that there was these cigarette burns. So if we accept that as true, you're implying that that's a clearly erroneous finding. Is that right?
What I'm implying is that...
As, of course, the mother does acknowledge it. She says that the child ran into the cigarette.
That allegedly occurred a couple of weeks before DCF went out. So DCF went out and saw the child. So that is all I can say as to that, is that the child was observed.
Did the judge make a finding about how the burns occurred?
The judge credited third parties saying that the child, her mother, ran into a cigarette.
Well, the third party said that the mother said she ran into a cigarette, which of course sounds implausible to lots of us, but that's not quite the same as saying, I think the mother deliberately burned her with a cigarette or accidentally burned her with a cigarette through inattentiveness. We don't have a finding about exactly what happened, right?
No, there is no finding as to that.
I mean, there might be evidence to support
it. It is just a reiteration of what was said to the DCF official by the third party about what the mother allegedly said. There is no finding as to
One
that.
observation, would you agree that was not third party, was that the bedding in the home had cigarette burns? And the mother is,
I'm sorry,
the bedding in the home had cigarette burns. That was observed by a DCF social worker.
Correct. The bedding in the home was observed to have cigarette burns in the parents' bedroom. The child's bedroom was impeccable. It was absolutely clean, and there were no safety hazards. And whatever the safety hazards that were present in the home when the DCF investigator initially came out, 2 days later, When she came back also for an unannounced visit, they were remediated.
But
So
that
everything was
doesn't,
cleaned
the
up.
mess was gone, and maybe the mess is transitory. I read the description of the mess, and except for the adjective that it was deplorable or something, they don't really describe something that sounds that deplorable to me, but I don't know what the things were on the floor. I don't, you know what I mean? So maybe it was deplorable. And it's true that that's just on one, like a night and the next morning, and then it's clean. But the burn marks on the sheet, whether you clean them up or not, indicate that someone's smoking in bed and maybe falling asleep while doing it. Would that be risky enough behavior to warrant removal of a child from a home?
May I answer with what was also stated in the finding about that? Mother replied immediately that that was an old blanket and parents do not smoke. I don't remember, I apologize, whether it's
That's not an
parents
answer to
or...
the question. What, if it was true that there were cigarette burns on the sheets, if that was the case, as the judge finds, Justice Rubin asked, would that be sufficient for removal of the child?
I think that there would have to be further finding of the parents actually falling asleep in bed.
Okay, all right.
And it's just an implication, it's just an inference once again.
Well, you can have a pretty bad fire from smoking in bed, right? Killing everyone in the apartment.
Absolutely.
That happens,
Yes.
which is why people shouldn't smoke in bed. Maybe or at all, but certainly not in bed. I mean, I'm just trying to look at factors that are something beyond, and I have to say, the judge doesn't find that this or the cigarette burn, she doesn't find that any of that is the basis for removal. It seems like when you read it, the basis of removal is this is a lying drug addict who is not actually in treatment and is not actually going to stop taking drugs and doesn't really want to. And, right, I mean, that's basically the nub of the
premise.
of the whole decision. And I've never seen a decision like that before, and so I'm struggling with what is the limit to Catherine, you know, what does it mean? I mean, maybe this decision tells us leave kids with drug addict parents, maybe. And maybe it does that on purpose because maybe otherwise the government will, every time they run into a drug addict, remove his or her children, and maybe that's wrong. I know nothing about this factually, although I'll ask the department what their view is on this. But that's what I'm struggling with is maybe that's really the rule, and that's it. And someone can fix it at the SJC, I guess. But if it's wrong, or maybe it's right, I don't know.
But may I just add something?
Actually, I think I'm going to have to, at this point, Justice Rubin didn't really ask you a question, but he's
really.
expressed his concerns, and so other people can also respond to them. You're going to have to rest on your brief now because you've taken 5 extra minutes of your time.
Okay, thank you very much.
Sorry.
May it please the court, I'm Sherry Krasner here on behalf of Mother as her successor appellant counsel. Excuse me. I don't know if I should be happy or glad, but Justice Rubin's questions.
You never know, so just make your argument.
I'm going to have to really throw out the beginning of my argument and move somewhere else. But before I do that, I want to talk about this issue of Mother possibly being a liar and how that seemed to undercut or undergird so much of the judge's ultimate decision about Mother's fitness. And that's all based on this suggestion that Mother introduced records that had been altered or tampered or
Yes, we've read that your argument that that's inadequately supported by the record, but liar is certainly adequately supported by the record. I've been sober since 2015. No, every month you test positive for drugs is not the truth. So.
Well, this mother was consistently going to a methadone clinic.
And consistently not taking methadone and buying drugs on the street and testing positive for fentanyl. Okay.
There were discrete episodes, about a dozen over the period when the child was...
that's a lot.
I would suggest that between 2019 and 2022, that those dozen episodes, I'm not here to condone mother for
Okay.
doing that, but I would say that that was not necessarily a relapse, that was not necessarily lying to the court, that in mother's head, she was going to the methadone clinic consistently. When she did not go, she bought fentanyl, and in those discrete...
Is your position that, or let me just ask it a different way. How do you read the law? If you have a serious drug addict as a parent, or let's actually make the hypothetical stronger, although I don't know if we have this for the father, but 2 drug addicts there's some evidence of that for sure, as parents. And DCF discovers this, and they're shooting heroin or fentanyl, worse even. Can the child be removed for her safety?
The department has to act when they believe that the child is in need of care and protection. If, on the basis of that, they believe that the child is in need of care and protection, that can serve as a basis for the removal.
Okay,
That's
so now
not-
let's keep going. Then, if that's true, then we have Catherine, which says, but you can't terminate parental rights. And I'm not sure I understand Catherine. Its writing elides some important questions. But, okay, a year passes, and they're still full-blown drug addicts. But you don't terminate parental rights. And 2 years pass, and they're still full-blown drug addicts. Maybe you still don't terminate parental rights. Do you have to leave the child of these addicts who may not be in the home, in limbo, in foster care? You can't try to get permanency for her through adoption and termination of parental rights ever?
Catherine, which has been good law for a quarter of a century, the parents in that case, the appeals court, this court found that there was support in the record that the parents had a habit, that the parents have not cooperated with programs, and that the habit will continue.
Indefinitely, yes, it does say that.
That's what the
why
parents...
I'm having a hard time understanding Catherine, because this would be very odd to me that you can remove a child, and regardless of whether the condition that warrants removal, you can never terminate parental rights. What kind of life will that child have?
But that's not what Catherine says, because Catherine then goes on to say that you can use that past conduct to predict whether there has been a pattern. However, you can't predict catastrophe when the care of the child has been on the whole satisfactory. That's at page 33 in Catherine.
Then how can you remove the child?
You can removal...
Isn't that based on a prediction of catastrophe?
The removal is done because of a current circumstance that warrants it, and then after investigation, then if a determination is made, and in this case, the care on the whole was more than satisfactory. I mean, you talk about the mother continuing to be on drugs, but between 2016 and 2019, if she was using during that time, the child was going to the pediatrician.
I completely agree with you. She was using during that time. I completely agree with you because we have drug screens from virtually every month that are positive. So I agree with you that there is no evidence of any kind of abuse or neglect of the child in the parent's care, except that they are both serious drug addicts. There is evidence of that, and I mean, that's what this comes down to for me is, and what is DCF supposed to do? And I find it very odd. We know that children can't be adopted after a certain age. What is it we're consigning these children to? We won't let them be with their parents, and yet we won't let them be adopted. How can that ever be in the best interest of a child?
A DCF legal case is not the same as a DCF clinical case. No one is saying that DCF shouldn't continue to be involved in this case. No one is saying...
Yeah, they do a great job. They can move them from foster home to foster home to foster home until they themselves run away from home, are on the streets, and wind up having children who are also in DCF care, which we see all the time when kids are not found a permanent home. It's not better than a permanent home.
when I talked about a clinical case, I wasn't necessarily talking about the child remaining in foster care. I was talking about the child remaining with her parents, and all eyes, the child would be in school, the child would be going to her doctor.
How about at night when the parents shoot up and nod off and a fire starts? There's no one there then.
That is true, but that's not the circumstances in this case.
Are
That's
you
not.
implying that if it was a clinical case and DCF stayed involved, the social worker, and that had periodic unannounced visits,
Certainly.
that social worker would hypothetically or actually in practicality would, who is trained to understand when things are getting worse, et cetera, would then say, I think things have gotten to a point that the child needs to be removed. But it might not come to that point. Is that what you're saying? That would sort of
Certainly,
happen?
and there would be eyes on the child, too. There would be releases.
What about this? Don't you have to have parents that are willing to have DCF be part of their home in that way? And here there was some issues that lots of recalcitrants there. But DCF was not always allowed to come in for home visits. They were put off a number of times.
At the early part of the case, there certainly were issues. I would ask the court to look at the testimony of the social worker who was assigned to the case prior to trial, a few months prior to trial, and her testimony does indicate that the parents were cooperative with home visits. My client at least had signed releases, which had been a problem prior. So at the time of the trial.
I'm not going to argue with you in the sense that the judge found to the contrary with respect to some of the releases. So, but we don't have to quibble about that. The record will support what the record supports. But you would have to have a family that was willing to do that and not disobey court orders or disobey any advice, so to speak, that DCF to give them. All right.
Certainly, but remember what's at stake here. It's permanently extinguishing someone's parental rights. It's an enormous issue and should only be done in extreme circumstances when this warranted. I see I've already gone over my time, so I rest on my brief.
There are a
have
few
one
more
too?
questions for you, so.
Okay, so have you been in touch with your client?
Yes.
How
I mean, I'm a successor counsel. I spoke to her when I was first assigned on the case.
How long ago was that?
It was approximately 6 to 10 weeks ago, and she was made aware of today's argument.
So you know her whereabouts and a way to contact her?
Again, that's outside the record, but.
It is, but, yeah?
Yes, I do.
Okay.
What weight should a judge attribute to a mother who doesn't appear for trial?
The judge is certainly free to make and should be making the negative inference, but it's not at all clear from this record why mother did not appear at trial. Thank you, and I rest on my brief.
Thank you.
May it please the court, my name is Carol Frizzoli, and I represent the Department of Children and Families. After the third removal of this child from her parents in her short 6 years of life, the trial court found that there was clear and convincing evidence that mother and father were unfit and were likely to remain unfit for the foreseeable future. Given mother's repeated struggles with substance abuse throughout this case, resulting in the 3 removals, and father's refusal to acknowledge mother's struggles as well as his own.
Do you think that the judge found abuse or neglect?
I'm sorry, Your Honor.
Do you think that the judge found abuse or neglect?
Yes.
What was the abuse or neglect of the child that the judge found?
Again, it's the abuse and neglect of the child was parents' mother's repeated substance abuse issues, which were evident in the case, and father's failure to protect this child from
Protect
mother's
from
substance. From mother's substance abuse issues.
Explain to me how I don't understand how that works at all. The mother's substance abuse issues aren't leading her to hit the child, right? They might be leading her, although we have no evidence of this, to be out of it or something when she's supposed to be caring for the child. How do you protect a child from a person not paying attention to them? I don't understand that.
What is in this record is you have to go back to the beginning where the reason the child was removed in the first place was mother was using substances during her pregnancy. The child had
That's
to
5 years before this, and whatever it is, Catherine tells us that that's not enough.
Again, I'm trying to put the
Okay,
history
please, I'm sorry to
together.
interrupt.
So you have that. That's what involves state intervention in the first place. A mother who was using during her pregnancy, resulting in the child being born abstinence, addicted to drugs. So the department works with this family. They return this child to the parents. Again, the parents have the child for 3 years. Again, this is a young child. During that period, what we have in the record is evidence of this. So mother is found one night wandering a parking lot.
That's the mother. What evidence in that 3 years, the first 3 years of this child's life, that the child was abused or neglected?
Again, for that first, after she was returned, so the first year she spent in foster care. So she was returned and then remained with the parents. But again, the child wasn't.
That was 8 or 9 months, right? It wasn't a full year, right?
Yeah, it was, but
Okay.
yes, you're probably correct, Your Honor. Again, during that time period when the child was not, an infant, not in the community, yes, there is, during that period, there's no evidence in the record of any abuse and neglect. The department would concede that. Again, what resulted in second state intervention
incident in the parking
was
lot
the
with
incident in
the-
the
yeah.
parking lot and the
then the
police
view-
coming in,
the
viewing.
conditions of the
How is that abuse or neglect? The father was sober and in the apartment asleep, as was the child. If there's two parents in the home and one of them wants to go out and get drunk, I don't like it, but I wouldn't call it abuse or neglect.
But in this case, when the police entered the home, there was drug paraphernalia out in the apartment. This is a young 3-year-old child.
So they removed the child?
No, they did not. The
No,
police
they
didn't.
didn't.
The
And
police did not
DCF
remove
didn't the next day, or the day after that, or the day after that?
Again, the department of the police filed a 51A report. After the investigation, when the department did their, legislative duty to investigate this 51A report, they talked to collaterals. They found out from the third-party aunt, who basically said, yes, I've seen the parents we suspected were using it at the holidays. We also, they investigated the cigarette burns that we've spoken about before.
Did you conclude how they were caused?
I'm sorry?
Did you reach a conclusion about how those burns were caused?
No, we
Okay.
did not. No, the department doesn't usually. They just take a collateral of all the evidence that was during the investigation. The investigation also revealed, they asked the parents, because the father in the police report had disclosed that he was a substance abuse user, and the police officer observed track marks on his arms. So the department went through their investigation. They asked the parents to verify their sobriety. Neither parent provided any kind of releases. Mother had said she was going to the methadone clinic, would not provide any releases. Without the kind of verification that these parents weren't using, they did remove the child.
Okay, so, and I don't mean to be argumentative in my questions about because it doesn't matter really, but I also don't mean to be argumentative. So let me ask you the question that I asked your sisters. We have this case, adoption of Catherine. It seems to say 2 addict parents isn't a good enough reason to terminate and might not be a good enough reason to remove. It leaves that question open. What is DCF's position on those 2 questions?
Well, I would break it down on 2 different, because with respect to removal, Your Honor, the standard for removal is much different than a standard for termination of parental rights. It's a preponderance of the evidence, so it's the factors at the time of the incident. So there's that standard. So I don't think Catherine is as broad to say that, the department has to leave a child in, substance abuse.
It doesn't say that, but it leaves that an open question. It does not say you can remove. It doesn't say you can't. It says we're not prepared to say that you can leave the child unsupervised there, and the remand includes, so look at fitness.
But in Catherine, I think Catherine is more narrow than Your Honor would suggest, in that it's the facts of that case, where with that family in Catherine, they had evidence of this parent's only, there was 2 siblings in that case, but the only evidence they had was the parents' parenting of Catherine. And in Catherine, there was no negative evidence of any abuse. The social worker testified the only issue was substance abuse, but they took great care of the child. That's not this case, and I don't think Catherine has expanded that.
What's the evidence of abuse? I asked you, that's my first question to you. What's the abuse or neglect? And I thought you told me it was them being drug addicts.
At what time, Your Honor? I mean, in this case.
From 2016 to removal.
So again, there is no evidence in this case.
Okay, so it's the same as Catherine.
No, it's in Catherine, which was the termination of parental rights.
This is too?
Correct. But in this case, we have other evidence. We have evidence that the parents were using, during the time when they were caring. Yes, so substance abuse.
That's
so
the
for the
same.
first 3 years, it's similar to Catherine, but it changes in our case.
What is the change?
The change is at the time the parents, the incident in the parking lot, during that time period, after the child's removed, there is a second trial, a permanent trial. Neither parent even appeared at the trial. During that time period, the mother was using.
There was consistent visitation.
Yes, there was consistent visitation.
Visitation went
the parents
well.
didn't address any of the reason for the removal through services.
That sounds like Catherine. They refused to go to services.
They refused to go to services, but in this case, again, there was that's why at the second trial, or the first trial in this case, the trial judge found that with respect to mother, who had done was not consistent in her service and her drug treatment, didn't find, she was found unfit. Mother did not appeal that decision of the first trial. With respect to father.
That's not quite the same as conceding unfitness. You don't have to appeal to right? She lost at trial. There's judgment against her, but they contested it at trial, right?
Well, again, they contested it at the second trial.
You don't think that a lawyer for the mother contested her unfitness at the first trial?
Oh, yes, of course.
Okay.
But the parents hadn't even shown up. The first trial, they didn't.
The parents hadn't, but their counsel had. I don't like the parents not showing up. I don't like that they're not here, right? Lower courts are allowed to draw a negative inference from it, but I don't know how negative an inference. Do you see what I mean? It isn't actually abuse or neglect to not come to trial.
But in this case, it is. It's the chaotic. If you read the trial judge's conclusions, it's that chaotic, the failure to provide a stable environment for this child. At the second trial, the father was given
because it was a mess. I'm sorry. Yeah.
No evidence. Was there any evidence of unstable housing, unstable employment?
There was evidence at the first removal that the grandmother was supplementing, paying the.
So they had someone to rely upon.
Yes. Again, that there wasn't, but again, it's that stable environment of 3 removals of this child alone based on the parent's lifestyle, which, again, the trial judge tried to give father the opportunity to parent this child.
So let me interrupt you. So in other words, this is the first time I've actually heard something that's different from Catherine. You're saying that the fact that the parents caused an environment that in a short period of time of the life of their child, the child was removed 3 times, that shows upheaval. It's just that in itself. It shows upheaval, sufficient so that the judge could consider it. Is that what you're saying?
Yes, I am, and that's what the trial judge did that.
How can the removal itself count as upheaval? I don't get this. You gave the child back to the father, finding him fit. And the reason it was taken away wasn't drugs or anything else. It's that he let the mother be there. Obviously, you wouldn't do that. I wouldn't do that. There's a court order prohibiting it. So you don't do it. I get that. But the court order itself is premised on exactly the same thing, that there's a danger from being in the same house as the mother. And you haven't told me why it's dangerous, if there's a person who is not under the influence with her, why it's dangerous for her to have her heroin addict mother in the same house. I understand why it's crummy. You know what I mean? But we have all these cases saying, look, we're not, we don't remove kids just because we could put them in a million times better a house, right? We're not allowed to do that.
But again, I think you get back to, it's not the removal itself, but the reason for the removal was mother's drug use and father having drug paraphernalia in the apartment, and father acknowledging to the police officer that he had substance abuse and the observation of track marks while they have a young child in the home.
Have you seen cases where DCF has put in expert evidence about the inevitable outcome of drug-addicted parents? In Catherine, it seems to me this is the biggest thing it leaves open. It says, well, if you had an expert say inevitably this is going to lead to catastrophe, that would be a whole different story. Do you have such witnesses? Have you ever had one? I don't know why one wasn't put in here. If you do, just because Catherine exists,
Again, I could speak to whether, I'm sure there have been experts used in the past, but I don't know. This case, there were other factors. I mean, we had, parents' testimony, third parties' information unchallenged about, cigarette burns while the child is in their custody. We have the parents, again, after father appeared at a visit, refused to take a drug test to see, whether he was,
I'm assuming he's a drug addict. That's him being a drug addict is part of the premise of all this. And I don't say Catherine is right. And I don't say you should leave a child with two drug addict parents. We have to follow Catherine if that's what it means. I don't know that it is, but if it is.
But Catherine had evidence that the parents were actually good parents. Like, there was no negative evidence when the parents had care of the child.
The judge didn't rely on the Christmas party or the cigarette burn. She doesn't mention, she finds it, but that's not, she doesn't say, and indeed, it endangered the child by X or Y. She never finds the child is endangered by anything except the drug addiction itself.
It's the drug addiction with respect to the mother, the failure to address this through services and put I think what's really prevalent in the judge's findings is that the parents they don't put the child first.
That's
in this
exactly
case.
what Catherine says.
Yeah.
It says, I have no doubt that if these people had to choose between drugs and their kid, they'd pick drugs. Now, I didn't write that case, right?
Oh, Justice Cass.
Justice Cass wrote that case. And was a great writer and a good judge,
I don't know if we have more questions because we have gone over, but we've gone over with everyone. We appreciate all your patience. These cases are always difficult, and this is also one. So you're also over your time, so we'll have
Thank
you
you.
rest
I
on
would
your
rest
brief
on my
now,
brief.
and we'll hear for counsel for the child.
Good afternoon, I think. Carrie Bagnall. I represent the child in this case. I've actually represented the child since August of 2019. On behalf of child, but I want to make clear today, not just on behalf of child, but with child's direction and insistence, I am asking this court to affirm the Brockton Juveniles Court judgment terminating parental rights and to free my client up for adoption. I'm going to go off script here, to address your concerns with Catherine. I don't read anything in Catherine that talks about removal. I agree with my sister here. Removal is a much lesser standard. And I believe that if Catherine were challenged on a removal, it wouldn't be found to stand for the fact that the department or anybody in society has to stand back and watch for harm, physical harm or neglect before their eyes, before a child can be removed from a drug addict. I'd also ask and point and remind this court and point this court to some other relevant factors regarding the removal of this child, and I'm talking the second removal in August of 2019, that it wasn't just based on mother's drug habit, suspected drug habit, father's suspected drug habit, though I will state that the evidence was pretty clear that the professionals, the police department, had a right to suspect that when you have spoons, needles in the bathrooms, track marks up both parents' arms. But it was also based on fathers and mothers' unwillingness. The removal of my client was really based on fathers and mothers' unwillingness to address these issues with the department. The child was not removed right away. I think the child was removed 10 days later when, after numerous attempts to meet with parents, and I believe the language was to draft a safety plan, the department went to the court with a petition, claimed that the child was in need of care and protection, and was granted temporary custody. That petition didn't have one paragraph that we suspect or we know parents are using drugs, and therefore we need to take the child. That is not what happened in this case. Child has been removed from her parents essentially 3 times. Child, I would argue, was abused and neglected prior to being born.
Yes, prior to being born, but that's old.
Well, when you're
Catherine says that's old.
She spent her first 3 weeks. She spent weeks in the hospital detoxing.
I couldn't be more against prenatal drug use and its consequences. They're devastating. But we have Catherine where the same thing happened. And in fact, the removal took place in Catherine because yet another child was born, also drug exposed. And that's what tipped off DCF that there were still drugs being taken. Right?
Well, this case is factually different. These cases are factually driven. Nothing in Catherine speaks to adoption of Nancy, which tells us we don't have to wait for the inevitable to occur. It is a collection of facts here. You have a father who is putting himself forward, and in some respects, the court after the hearing in June of 2022 gave him a chance, said, hey, I'm not a drug addict, she's the drug addict. But look at his actions. He refused to meet with the department, which led to the child's removal. Both parents, by the way, waived the 72-hour hearing.
Is that a concession of unfitness?
It's not a concession of unfitness, but it's a concession to go forward, and put forward the reasons why the child shouldn't have been removed. Both parents neglected to show up for trial.
Twice.
I personally view that as abandonment. I know it doesn't fit the definition, but you have to cooperate a little bit to try to get your child back. They did the opposite here. They lied to the department. They lied to the court. Father sat there and said he understood those conditional custody orders from the court, and he'd abide by it. And very first chance he has with my client, overnight, mother's in the house, contrary to the order.
So let's say
he wasn't able to put her in
let's say we agree with you about removal.
Mm-hmm.
If you're right about removal, what do we do with Catherine? Because this is not just an unfitness hearing, this is a termination hearing. And I mean, the stuff you're adding, it's not really what the judge relied on. Maybe a bit, some of the failure to cooperate by the father, and drew negative inferences from the failure to be at trial.
So those negative inferences were if the parents had shown up for trial, they they would not have had the ability to counter mother's numerous fentanyl and cocaine positive tests.
Oh, no, I agree with that.
That father probably wouldn't have been able to answer as to why, when asked a year prior, within 24 hours to get a supervised drug test, that he didn't. So, and the judge did draw a negative inference that they would not have been able to establish sobriety, cooperations with any professionals, and I just don't look at Catherine that you put a child behind a door and just hope for the best with two known drug addicts.
My only concern is that Catherine says you can't terminate parental rights just because people are addicts. And if this is an appropriate case for termination, we have to...
We have cases that you can terminate based on their inability to cooperate with the department, their inability to recognize the very thing that puts that child in danger, and not address when services are offered.
That's true, but what we've been questioning is that level of danger. I mean, you can imagine, for example, of course you can't leave a child behind a door and just wait, but there are drug addicts who have resources, wealthy, maybe they have a nanny live in the house.
These people had an opportunity to meet with the department to discuss those resources, that safety plan. They chose not to, and the child was removed as a result. Once the child was removed, they refused to cooperate with the department, participate in any meaningful services, continue their drug use.
And so,
and
if I understand you correctly, what you're saying there is that refusal to engage in the service plans, that refusal to cooperate with the department, let alone disobeying a direct court order on the part of the father, that is a form, in your view, of neglect.
Neglect, and those are things...
Even though it's not physical danger, that's, in your view, it's a form of neglect.
I view it as such.
Well,
I personally know if my children were outside my care, I'd do anything to get them back. But it's all of those things together, and the court was allowed to use those things in coming to the ultimate conclusion that parents' condition was not acknowledged nor addressed and would likely continue in the future, and that my client was entitled to a future at 6, almost 7, of stability and permanency, which she has achieved.
I didn't do the math, but how old is your client now?
She turned 8 in August. She's, and, you may recall,
Is she with the foster family or the C family?
Oh, no, she's with the C family. She was placed with the C family almost immediately after the trial in July of 2022. And she lives with them and her cousins, and...
When was the last time you spoke with her?
I saw her yesterday, Your Honor.
In person?
Yes.
Great.
She's beautiful. She's happy. She's starring as an elf this weekend in her first major production. She's just, she wants to be adopted.
Be careful about not
Yeah,
we understand that there's always an issue about taking things outside the record, and
but
we know that.
you are telling us that I know what the CPCS rules are about representing children. You are telling us that it is her position personally that this should be affirmed.
She wants to be adopted.
And so this is not substituted judgment. It is, in fact, her judgment.
And I substituted, and I do trial work, and I'm clear on the record when I'm substituting judgment.
No, I saw you said that. I didn't know it was you, but I saw in the transcript below, or somewhere you said, this is substitute judgment, because you have to, at least under the CPCS rules. If you're doing that substitution, you have to say, she thinks this, but I'm substituting that.
Right, and she wasn't mature enough to really understand the proceedings, but yesterday, she's 8.5 almost, and she wants this court to affirm the lower court's decision, please.
That was the position in her brief as well, so, okay. Thank you very much. Just a couple of things. We know how difficult these cases are. This case is particularly difficult. Maybe that's unfair to say because they're all very difficult. So we will give the case our utmost attention, take it under advisement, do our best to get an answer as soon as we can. And we appreciate all of you spending the extra time. Everybody went overtime to answer our questions. We appreciate that as well. And I do want to assure everybody, to the extent that both sides of the table gave us information outside of the record, we know exactly where to put that, how to consider that, and we will not do anything that is not provided for by the rules of appellate procedure. Okay? All right. Thank you all very much.